Okay, the Civil Service Commission regular monthly meeting for May the 12th is now called to order. It is 2 o'clock. What is it? 2:02 p.m. I start with the land acknowledgement. I would like to acknowledge that we are on the traditional land of the first people of Seattle, the Duwamish people, past and present, and honor with gratitude the land itself and the village. We are here to do the work of the Seattle Civil Service Commission, whose responsibility is to ensure that Seattle City Workforce reflects the shared values of its community, respect for the indigenous people, and committed to holding each other accountable. That being said, we'll begin with introductions. My name is Ray Caesar, Chair of the Commission, and we'll start with the other commissioners.
Denise Wells, Commissioner.
Amira Whiteman is joining us up by sail. I'm not sure if she can hear us, but she's present.
Mary Wiseman Williams is here, present.
Well, thank you. And other, the director staff can now introduce themselves.
Oh, I'm Andrea Shealy. I'm the Executive Director of the Civil Service Commission.
I'm Sarah Butler, Operations and Policy Advisor.
I'm Teresa Jacobs, Executive Assistant.
Joe Levan, the legal counsel for the commission.
Okay. The next order of business is public comments. Do we have any public comments tonight?
No.
Hearing none, we'll move on to the next order of business would be the approval of the minutes for April the 14th of 2025. It's been distributed. Are there any corrections?
None for me.
Great. And do we have a second on the approval?
I second the motion.
Great. The minutes has been moved and seconded. All those in favor, say aye.
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 Those who oppose, say no. Hearing none, the minutes for April the 14th of 2025 is approved. The next item of business. Today we have a guest speaker, Mr. Mike Chen, the Director of the Civil Rights Department of Seattle. Is that correct? Okay. And,
You can come on up and introduce yourself.
Thank you so much. That was a big promotion on the record.
Okay. All right.
Public Service and Safety Service. Should I just
Yeah.
do it this way? Okay.
Yeah.
It's so hard to know. There's a couple folks online here. Hello, my name is Mike Chen. My pronouns he, him, and my official job title is the Civil Rights Enforcement Director. I serve the Seattle Office for Civil Rights, and my director of the Office for Civil Rights, Derek Smith. And so he is the director of the Office for Civil Rights. So today, I want to just thank you all for inviting me to come and speak about the work specifically around the civil rights enforcement, and also the touch points between the Seattle Office for Civil Rights when we do investigations and the work that you do on this commission. And then also provide you some opportunities to ask me any questions around discrimination laws, civil rights enforcement, and other questions that you may have as commissioners or have questions about the work that we do. So I'm going to, can we get the PowerPoint set up, or do you want, should I get my?
I did not.
Oh, yeah, I actually didn't log on, but
Yeah. Well, here's what we can do. We might have to, I'll have to email it. No, yeah. Can you access it through your email? Gosh. Well, we'll have, we got to get it up somehow. So if you, oh yeah, Sarah, I can do it. Thank you, Sarah.
you sure, or do you want me to do?
No, I have a laptop that's just like I heard you for that. So
Oh,
yeah.
I want to, sorry.
Yeah.
Yeah, no, I think I think I was gonna come in person just because it's sometimes easier to do presentations in person, but I can also just log in here and share my screen.
Okay.
Well, it's in the packet also, so if you wanted to run it from the packet. The agenda
Yeah,
packet.
Let me see if I can do this. I apologize. I should have.
This is perfectly fine. It'll work just very well. Let's see. Let me join the meeting. Let me grab the thing first.
I can also join the meeting too.
I can do it, Mike, and then you'll tell me when to switch
Are you sure?
slides. Yep, yep,
Sure. Okay.
yep, I've got it up.
Okay.
Just join the meeting. And then I'll be.
Well, as we're loading this up,
Hold on one second.
okay.
You're good. You can talk now.
Okay. Do you folks see the PowerPoint?
Not yet.
Not yet?
That I'm still working on, but I'll get there. But you can speak.
Are you sure? I can just join.
No, I'm
Do you
doing
wanna
it.
do it? Let me just join and I can share screen.
Got it.
Okay, we can
I'm
see it.
looking, I'm looking at it through the packet. It's pretty visible for me, looking at the
Okay,
packet.
great. Well, first of all, I wanted to start off by saying I know on the first title, it said attorney-client privilege. That is not correct. So I already found one error. Thank you, Joe, for pointing that out this morning or this afternoon about the first mistake. I actually was probably preparing this for a different purpose. And like most city employees, we recycle a lot of stuff that we have. You know, we want to reduce, reuse, and recycle. But I actually didn't take that out of the text. But this is actually more for educational purposes, for your education, for your awareness, and to hopefully ask some questions about the work around enforcement. So let me give you a quick overview about our department. The Seattle Office for Civil Rights, we have about 35 employees, and we are spread out around 4 different main divisions. The Civil Rights Enforcement, which is the largest division. We have our Policy Division, Race and Social Justice, our Community Investments, and our Commissions. And to give you a little bit of background of each of those before jumping into civil rights, our policy division really advises the mayor's office and city council on public policy issues. Our race and social justice, it's been what, 20 years in race and social justice, and it basically identifies areas of structural and institutional racism in the city and how we provide services. And so it's very much internally focused around employees and public engagement. Our commissions team, we support 4 commissions: the Seattle Women's Commission, Seattle Human Rights Commission, LGBTQ Commission, and the Disability Commission. And then our community investments, which was a division that was set up a couple of years ago for community and participatory budgeting. So the city council gave the city of Seattle, or the Seattle Office for Civil Rights, a bunch of money to engage with communities, to identify areas where resources should be put, and that has been divided into many different city departments. So, but our office primarily focuses around civil rights enforcement, and we are a leader in terms of providing civil rights and equal opportunity, and to eliminate discrimination in housing, employment, and public places. Next slide, please. So I'm going to talk a little bit about civil rights enforcement and what that is and what it's not too, because I think that people, when they think of civil rights, they think it covers all areas, and that may or may not be the case. So our purpose is to ensure equitable access in employment, housing, public places, and contracting by enforcing the city's anti-discrimination laws. And when we talk about employment, which is the setting that we're going to really be focusing on today, is around city employment. Okay, but I also want to just acknowledge some of the other areas that we do enforcement in: housing, which is the majority of our cases; employment, public places. So any businesses that operate in the city of Seattle has to comply with anti-discrimination laws, anti-harassment laws, and also city contracts. Any contracts that are that are commenced in the city of Seattle, whether it's for program and services, also cannot have discriminatory language in all of our contracts. And we oversee some of the Title VI contracting language across the city. So we actually have a very expansive view of civil rights enforcement. Our 4 areas of enforcement is in investigations. That's kind of our main priority and the largest team that we have on the enforcement division. And I'll talk a little bit about what our work looks like in that. We also do outreach and community engagement. So that's basically education, outreach to communities and businesses about what the civil rights laws are in Seattle. We also have a code compliance testing program where we actually have testers go out into businesses to identify trends of discriminatory practices, mostly in housing, but we're also expanding to public places and employment. And we have the citywide Title VI program, which ensures that we are complying with Title VI of the Civil Rights Act. That is basically the requirement for the city to follow in order to receive federal funds. So in order for the city of Seattle to receive, I think the last, from 2020 to 2023 was about $1 billion of federal funding, mostly to transportation, public housing, or to housing, to public assistance, to police. Those are the main departments that receive federal funds. SOCR has to provide training, notice, and also deal with all types of complaints against any city department around discrimination. Okay. Next slide, please. So I'm going to talk about the 4 areas, and like I said, these are the 4 areas of law that we enforce, which is employment, housing, public places, and contracting. Really going to focus more around employment, since a lot of the cases that you see at the Public Service and Safety Civil Service Commission primarily has to do with city employees. These are the laws that we would be enforcing. So there's our fair employment cases, fair employment laws, Americans with Disabilities Act, which is a federal law, the Age Discrimination in Employment, Title VII, Genetic Information Non-Discrimination Act, and the new Pregnant Workers Fairness Act. So you notice that there's 5 federal laws that we also enforce. We enforce this with our partnership with the U.S. Equal Employment Opportunity Commission. And what that means is that if someone in the city files a complaint with us, they're not just filing it under the city law, it is also under federal law. And we have jurisdiction over enforcing federal law. And they also do what is called a substantial review of our cases and through our partnership. Okay. I'm not going to talk too much about housing, public places, unless there are specific questions that people have right now or online. Any questions? Okay, next slide. So I want to spend a little time about what is discrimination, and why this is really important is because this is the work that we do. And this is where sometimes areas get a little gray. It's like, is this something that the Public Safety Civil Service Commission deals? Is this something OCR deals? Is this something that HR deals with? Who deals with employment discrimination issues? And so it really comes down to what is discrimination, right? And we all know that a simple definition of discrimination is when you treat someone differently, right? I mean, that's just the fundamental difference. Though the slight difference, what issues we look at is not just are you being treated differently, but is it based on what we call a protected class? And so in this slide, it talks about the 5 areas of what different treatment could look like, right? The first box is different treatment. That's what people are mostly like. Someone is being treated differently because of their sex. Someone is not getting a promotion, is being disciplined because of their race. Whatever the discriminatory or the different treatment is, and is connected to a protected class, that is where it falls under the public employment or fair housing or fair employment laws that we enforce. Okay. Disparate impact is a little bit different. It's where you have a neutral policy or practice that has a discriminatory impact on a certain group of people. So a number of years ago, the Seattle Police Department used to have a height requirement for people to enter to become police officers. To become a sworn officer, you actually had to be over 5'8". And that policy, as neutral as it seemed, applies to everyone, could have and did have a discriminatory impact based on sex, maybe based on gender, or based on other protected classes. And so what disparate impact is where you have a neutral policy practice that has discriminatory impact. I know a current issue that I remember this working with HR at the time was around driver's license requirement, right? There was a number of positions across the city that said, hey, you had to have a driver's license, even though you weren't even driving, right? Now, I would get it if you were a delivery truck, if you were a driver, if you were actually operating a motorized vehicle, that makes a lot of sense. But a lot of positions don't require a driver's license requirement. And that really forced the city to take a look at what are the jobs that really necessarily require business necessity to have a driver's license and which ones don't on a case-by-case basis, right? So those are examples of disparate impact. Harassment could be either a hostile work environment or quid pro quo, and those are when someone is being harassed or treated differently, or sexual advances because of their sex, or hostile work environment because of their race or national origin. Retaliation is when someone files a complaint with our office or requests a reasonable accommodation or complains about harassment, and later down the road, their supervisor then terminates them because they had filed a discrimination complaint with our office or complained about harassment and things like that. And then reasonable accommodation, which is a big part of our work, is accommodating a worker in their ability to be able to do the essential functions of their job, right? Person who's disabled and needs a job accommodation, and that is that process where we would be doing reviewing. So like I said, when we talk about discrimination, we're really talking about real specific types of act connected to protected class. In the next slide, I want to share with you all of the protected classes that are in Seattle. And so in your first column that you see on the left are all the federal protected classes. And so you can see that the federal protected classes are definitely a smaller list. But when you add state protections, it adds an additional 8 to 10 protected classes, right? Like creed, sexual orientation, gender identity, veteran military status, citizenship status, immigration status, use of a service animal, Section 8 housing subsidy, which specifically is for housing cases, so not employment, and alternative sources of income, which is specifically housing and not employment. And then in addition to, under our local ordinances, we have an additional 6 protected classes that are specifically not only just covers the federal protected classes, state, and the local, which is ancestry, marital status, political ideology, pregnancy outcomes, caste, and breastfeeding, which is under only the public accommodation laws. So you can see where it is a privilege to be working in Seattle with all of these protected classes. It's really interesting when I talk to other agencies across the United States about civil rights. We are the envy of many, many jurisdictions across the country. People contact us. Like I had a meeting with LA County just last week, had a meeting with Boston, talk about how we do enforcement of our protected classes. And even though we have a very large number of protected classes, part of it is educating the public about what these protected classes are and what they look like in these different situations. But it is a privilege to be here to work in Seattle, to know that these are all protected, especially in this time of day, where there's a lot of rollbacks in protected classes on the federal level. But one of the things that we can be assured with our partners with the state and with local jurisdictions is to say that we will continue to enforce our local laws that prohibit discrimination based on all protected classes. Okay, any questions so far? All right, so this is the primer about kind of what is discrimination, what our office does. So now I'm going to talk about what it requires to file a complaint. Why this is really important, this chart, is because I want to make sure that folks kind of understand our process and the laws that we actually have to enforce and how we enforce it. So number one, charging party contacts our office. Why this first important step is that by law and by federal law as well, a person, an employee who comes to our office actually has to come to our office to file a complaint and sign what is called a charge. Okay, a charge is basically a roadmap of what their allegations of discrimination and their protected class and kind of what happened, why they believe they've been discriminated. Why this is important is because we do not do initiations of investigations without the employee's consent. Okay, so that's really, really, really important. And that is why I'm emphasizing this point is because there needs to be a commitment from that employee to go through the investigation process. Now, OCR's role in this is that we are neutral fact finders. We are impartial. We do not advocate for the charging party filing the complaint. We do not represent the city, the city's interests at all. we are independent. We have to operate very similar to the US EEOC office because we are independent and we make independent finding based on the law. We are advocates for the law and we are advocates for the process. So we make sure that our process is consistent with what an EEOC investigation would look like. And we apply the federal and or local laws in all cases that we do. Okay, I say that and I emphasize that because I think a lot of city employees, one of the biases that we see is that, oh, well, you're another city department. You're like HR. You're like, I'm so always looking at you because I always know you, Sarah, in that context. And I apologize. I don't mean to point it to you because I think I catch myself that. But it's one of those things that I think that a lot of folks think that because we are a city department, and my director is an appointee of the mayor, that we do not do independent investigations, and that's not true. We actually have much more enforcement power if we find that there's been a violation of discrimination. And so we have that ability to actually take further action against the city department to ensure that we resolve the issue, remedy the issue that's being complained about. Okay, so number one, charging party contacts us. If we believe that it meets the elements to file a complaint, which is what? Different treatment based on a protected class, we draft up what is called a charge. We ask the employee to sign the charge. Now, if they don't sign the charge, then we do not automatically investigate. Okay, we are not mandatory reporters. I want to make that clear because I think there is sometimes people think that we are mandatory reporters. We are not. So when an employee comes to our office, we have the Seattle Office for Civil Rights similar to the EEOC office hat, and we are not mandatory reporters of that to that agency unless an investigation has been filed. Okay, does that make sense? Why we're not? Now, the next thing that we do is we do an intake, we file a charge, and then we investigate the complaint. And as a neutral fact finder, we gather all the evidence that's needed for a complaint. We gather where did it happen, who are the witnesses, what are the facts, the documents, whatever it is, to be able to basically investigate and complete a report of those allegations of discrimination. Anything outside of a discrimination case. So let's say that the employee is wanting to file a policy violation under personnel rules. They still have that right to file with HRAU. Okay, they still have that right to file at other venues of other possible policy violations in the city or whistleblower ethics issues. They have other avenues. This is only going to focus on the discrimination issues alone. Does that make sense?
Yeah.
Because,
Do you mind if I add something?
absolutely.
Yeah, so folks may even file with the Civil Service Commission after they complete a grievance process if their issue is not related to discrimination. So the Civil Service Commission could potentially see something that's going alongside an OCR investigation, and we'll talk a little bit. Mike and I will talk a little bit more about that later too.
Yep. And then we investigate the case, and then step 5 is the possible outcomes. And there's reasonable cause, which means based on preponderance of evidence that there has been a violation of the laws that we enforce. There's also withdrawal, where maybe a charging party wants to withdraw their complaint from our agency. There's also no reasonable cause, which means the evidence does not support a reasonable cause finding. Administrative closure. Examples of administrative closure could be we find out that it was outside the jurisdiction, or we find out that the incident happened outside of 1 year. So we have a 1-year statute of limitation. Maybe it involved other people that we don't have jurisdictions over. We would then administratively close that. And then we also have 2 other options, which is settlement and conciliation. Part of our work is to try to resolve try to assist the parties in resolving the complaint. So we have a settlement process, whether it's with the investigator, or we also have a mediation program that also helps the city department and the employee come up with a resolution that both parties agree with. And that is a private settlement agreement, and that is not subject to public records. It's like our investigations, it is subject to public records. Settlement agreements. Oh, I'm sorry. Yeah.
You keep going. I did something wrong to this.
Oh, okay.
Go ahead.
So we also have private settlement agreements, which is facilitated by our mediator, who is subject to the Uniform Mediation Act of Washington. And so that agreement is held separately from our public records access. And so that's an agreement between the city department and the employee, or it could be something that we facilitate, which is part of the public records. Okay. And all of our investigations, as you, might be a little bit different than HR investigation. It is subject fully, completely to Public Records Act. So it's subject to the Public Records Act. Both sides, whether the employee or the city department, can make a public records request for the information. There are a couple of exceptions to what things would be left out in in those records requests, but it is fairly liberal in terms of how we use them. So it's different than an HR investigation where there are some protections during investigation and things like that, but under ours, not the same level of protections.
So CR has an in-house mediator.
We do. Yep. We had an in-house mediator because we resolve about 20 to 30% of our cases. And so of those, probably 30 to 45% are actually resolved through our mediator, through our mediation program. Yeah. And it's actually a really useful program because we, especially in housing cases, we found that really helpful. We've actually had a couple of city cases where the mediator was actually able to find a settlement between the city department and the employee. And so it actually has been a very successful program. In the past, we have relied on what is called shared neutrals, where someone from King County or the feds would come in and mediate our cases. But that program has kind of been put on hold for various reasons. And so we are not, that level of service was not still available. So we ended up requesting for a mediator. So that's been a really good program for us. Okay. So to file a complaint, here's what is required. It has to occur in Seattle. Now I'm going to put a caveat to that because with city employment cases, even if you are a citywide employee that was working at the dam or other facility location that's outside of the Seattle city limits, you as a city employee are still covered. Okay, because the employer is the city department. Okay, so it doesn't actually have to occur in Seattle, but it's unless you are a city of Seattle employee, it can happen anywhere you're in. You're doing in conduct of your work. It has to be covered with laws we enforce, which we talked a little bit about, both federal and local laws. For employment, I don't know why I said 1 year. It's 1.5 years for employment. That actually got expanded. I was thinking a little bit different for housing. Housing is 1 year. And then we actually have to have jurisdiction over the entity. But if you are a city employee, we have jurisdiction over all city of Seattle employment, including contractors as well. So if it's a contractor, a sub, and you're working for the city, you would fall under our contracting laws. And so that is something that it does cover, which might be a little bit different than the public service.
We don't, the civil service and the public safety civil service don't have jurisdiction over those employees. It goes more to the job classification.
Oh, okay.
Over certain classification. Most classifications in the city are covered by one of these two systems, and this is the Civil Service Commission.
Yeah. Oh, okay. I'm sorry. Okay. I always just kind of combine it.
Well, this goes for both. I mean, this is relevant information for both commissions.
Okay. So I'm going to talk, next slide is about referrals to SOCR. So Andrea and I have had a couple of referrals that happened in the past, but wanted to kind of give you step by step of kind of what the referral process, and I'll also lean on to both Andrea and Sarah if there's other things that I might be missing. So if there is a PSCSC refers a complaint to OCR, and so what happens is that you want to talk a little bit about kind of how a complaint might come to you and how that referral might.
Sure, and I think, this does say PSCSC throughout, but we're talking about CSC primarily today. So if we receive, well, let me back up. For Civil Service Commission, actually, the jurisdiction is a little bit broader than for Public Safety Civil Service Commission. For Civil Service Commission, the Seattle Municipal Code gives this commission authority to hear appeals related to any serious discipline, so suspension, demotion, or termination, or violations of the personnel ordinance. So a couple of excluded subject matter like classification appeals are not appealable to this commission. But if we were to get an appeal and the facts that are underlying the allegations involve discrimination, we are going to we're gonna take notice of that. Because the law also requires the commission to refer any matters of discrimination to the Office for Civil Rights. So hopefully, but it does occasionally happen that it gets all the way to us before it's been referred to the Office for Civil Rights or HRIU, which is the Human Resources Investigations Unit. But if someone says, for instance, I was terminated because of my religion, my religious beliefs, then it sort of seems like we would have jurisdiction, and we would definitely ask ourselves that question. We do have jurisdiction over terminations for members of the civil service, but if the reason and the poor reason is an allegation of discrimination, we're going to have to take a look at that law. We also have a related rule under the Civil Service Commission Rules of Practice and Procedure, and we have case precedent that requires us. So we're pretty sure we are certain that we have to refer the matter to the Office for Civil Rights.
Great, thank you. And that actually helps create that foundation of how cases go from CSC to the Office for Civil Rights. So in step one, when there is a referral, there's actually a written communication that Andrew will send to me to say, hey, we are referring this under the code to look at discrimination issues. And so, like I said, what we will do is the PSCSC will consider whether it retains jurisdiction over any claim. So it's usually specific to the claim, is that right?
It's specific to the claim, right? And a case where maybe there are multiple allegations, we would retain jurisdiction over the claim in whole or in part. Where an employee says, I was fired and the reason is my religious beliefs, and does not have any other information that they believe went into the termination decision, is going to be entirely referred over to OCR. However, if the person says, for instance, I was terminated because of my religious beliefs and because I ran into a pole, but that is incorrect, I did not run into the pole, then we are going to retain jurisdiction over that appeal, and still do the referral to OCR, let all of those processes continue and conclude. And then if there is anything left at the end of the OCR process and the employee wishes to proceed, then we would make a decision based on the facts about whether or not we're able to proceed on those remaining allegations. Does that make sense?
Yeah. So let's use that example, because I think that's a great example where there's two different issues, right? There's the termination based on religion, right? And then also the allegation that the person hit a pole and they didn't think they hit a pole. So in that, when you bifurcate that, would the CSC make a decision on the pole issue, or would you wait until after the OCR investigation concluded before looking at both of those issues?
I would recommend that the commission hold the remaining allegations and any decision on those or even hearing on those in abeyance for the Office for Civil Rights to do its work with that complainant. Okay,
so then after that, and that's why I was just wanting to be sure, because I know that you hold the abeyance on the discrimination issue, but I didn't know if you held it for both.
No, we would not take any action because it seems like we would want the body that has authority over the jurisdiction over the discrimination claims to be able to do its work and find its facts. We don't want to conduct two sort of types of fact finding at the same time. Okay, great. So now it's in OCR's court, right? The referral comes over to us, it comes over to me, and the first thing that we will do is we will create what is called an inquiry. And so an inquiry is basically our internal records that we have a referral coming from the CSC, and we have documentation, we have the letter referring that there's a possible discrimination issue, termination based on religion, for example. And our intake investigator would then reach out to the person, to the employee, or I guess former employee at that time, I think. In a termination.
Yeah. Reached out to that former employee, says, hey, we received this referral. We would like to ask you to get additional information about your claim, right? Because we still have to do our own intake screening process to determine whether it still meets the jurisdictional requirements, whether it is something that is an issue that is covered under the laws that we enforce, and to see if other jurisdictional issues that we might need to consider. If the person does respond to us, we draft up a charge, we then go forward with the investigation, which I kind of explained a little bit earlier today. However, in some cases, we've actually had situations where that employee never followed up with us. So we actually have records of multiple contacts, sending letters, emails to last known address to say, hey, we're getting this referral. We need to get additional information, because just because it's being referred to us doesn't mean we automatically investigate it. We have to have their consent to investigate the complaint with their signature, okay? And in those situations where we don't have consent or they have not followed up with us, we will then follow up with a follow-up email back to Andrew and let you know, or the CSC know, that we were unable to move forward. In some cases, if we find out that we don't have jurisdictional based on the evidence they provided that intake and things like that, we would also follow up with the CSC, letting them know about our decision not to take the complaint. Are there any questions? And I know there's a lot of moving pieces, because this is something that we don't get a lot of, referrals, but it's also those things that sometimes the one-offs can really catch us off guard. And, but we want to make sure that our process is open as much as possible for either current or former employees to utilize our complaint process.
How does that work for the security side of the house? Even though we're contractors, let's say a city, we don't work directly for the city. Let's say a city worker is discriminating or harassing one of their security officers.
Oh, very good question. So, and so these are really interesting, because we've had cases similar, not in the context of city employees and and things like, but where we actually have to look at a couple different things. So if it's the contract security personnel who comes to our office to say, I'm being discriminated by a City of Seattle employee at SMT, we would actually treat that not as an employment case. We would treat it as a contracting case, because they are a contractor for the City of Seattle. Because what we're looking at jurisdiction-wise is who is actually filing the complaint, like that individual. So if it's a contractor, we would be looking at that person, and we'd be looking at the contracting laws to see if they were being harassed based on a protected class of contracting laws. Because what we're really looking at is employment. Employment law is different than contracting law, because how I describe it is employment is that there's that employer-employee relationship, which is a little different than a contracting relationship where you're contracted to. Now, we have seen situations like that in the past where it involves someone who works for Kelly Technical Services, but is on site at Amazon.com, right? And things like that. And we may even look at contracting employment relationship differently depending on how that relationship is established. So it really depends case by case. Yeah. Okay. All right. Let's go on to the next slide about if we were in a situation where we were successful in getting consent from the city employee to file a complaint with us. We do a complete investigation, and now we've made a determination. Remember, there are a couple of determinations, there are a couple of outcomes we could do. We could say reasonable cause, which means based on preponderance of the evidence that we found there has been a violation. There's no reasonable cause, which means there's a lack of evidence, or there's no evidence that supports based on the preponderance of the evidence. It could be a settlement agreement. We could also notify the parties that there was a withdrawal because one of the parties had entered into a private settlement agreement and has voluntarily withdrew their complaint with our process. We would also send that to the CSC for their awareness and see how they would handle things, that might be resolved or may not be resolved. It could also be administrative closure, right? Where we found out that the person decided to file a complaint and did not cooperate with the investigation. Whatever the outcome is, we would be providing the official report to the CSC and to let them know that we have closed it on our end. Now, here's a caveat. There's always a but for, right? There's always a but condition. Appeals. So under our law, and this is something that Andrew, we could probably maybe talk a little bit, a little deeper about. So if we find no cause, so basically the evidence doesn't support a violation, that employee or former employee still has an appeal period. You can file an appeal with the Seattle Human Rights Commission, which is one of the commissions that we support. And the Seattle Human Rights Commission has an opportunity to review the investigation to determine whether the investigation was adequate and was sufficient to support a preponderance of the evidence. And Joe, definitely you can speak to this, Joe, because I know that Joe has also helped the Seattle Human Rights Commission in these cases. But one of the things that, they do have an appeal period under our process. I would be thinking that we would wait until after the appeal period has ended before we probably send that report to you, just to give that person the ability to exhaust all of their administrative remedies before giving you the final decision of the, of OCR. But I was just kind of thinking about this.
How long's that appeal period?
It's a 30-day period, but if they do appeal within that 30 days, we would, the investigation could be a remand investigation, it could be affirmed by the Human Rights Commission. Sorry to kind of throw this on the spot, but I was actually thinking about that, and Joe kind of gave me the reminder about the appeal process, about some things that we should consider. But those are some of the things that we would probably want to consider in the case resolution with the CSC. And then you, I guess, on step 2, review the finding, determine if the finding addresses the discrimination issue in the civil service grievance, because that's something we would not be doing. We wouldn't be anything aware of what the other outstanding issues are, and that is something that the CSCA would be looking into. Do you have anything to add, Andrea?
No, yeah, Mike's correct. These come to us very rarely. The types of appeals, and commissioners are familiar with this, are usually about discipline and usually about a disagreement about the underlying facts or even the adequacy of an investigation. But we don't usually see discrimination allegations in our appeals. There are many other places, as Mike's representing one of them today, for employees to go to if they want to talk to someone about discrimination.
Okay. So the last slide, second to the last slide is around investigations, because I kind of thought I would end here to kind of give folks about kind of like a feel of the volume of the work that we do and the people that we support. So in 2024, we do about 856 intakes that come into our office. Most of them are in housing, employment number 2, and public places number 3. In terms of city employment cases, this is probably what's going to be interesting. We probably get about 10 to 15 city employment cases that are filed with our office. Now, I do know there are some city employment cases that go to the Washington State Human Rights Commission. Some are handled by the U.S. EEOC. Both of those 2 agencies do have a backlog, by the way, about 6 months, 6 to 9 months backlog. It is a bit of a wait period, but it is something that they do have different avenues, just like what Andrea talked about, that city employees can go to EEOC directly or to the state. There is no requirement to file with SOCR or a civil rights violation. Of those 856, we probably conduct about 300 and some intake interviews, and that's the process where we're actually talking to folks to determine whether this is something that we can investigate. Of those, about 98 last year got filed. Got filed last year. We resolved about 88 cases, and appeals, we had about 15 different appeals of those cases that were no cause or administrative closures, where the charging party wanted the Human Rights Commission to review. Other kind of facts I wanted to kind of share with you around resolutions. 51% of the cases that were resolved were housing. 25% were employment related. Public accommodations were 11%. 8% were city employment cases that got resolved last year. 9% were fair chance housing cases. Like I mentioned before, about 30% do get resolved through some sort of a settlement process. And that is it. The last slide is around any questions, and it has my contact information. Does anybody have any questions? information shared. Yes.
Consider, regarding the intake, we got 856.
Yeah.
And the cases filed is 98. Is there something to read in between that where there's so many people calling in versus how many just move forward, I guess?
Yeah, that's a great question. So of the 856 that come in, a number of them, a great volume of them we don't have jurisdiction over. So if you Google Seattle Office for Civil Rights, the most likely you'll see is U.S. Department of Education Office for Civil Rights, HHS Office for Civil Rights. You get a lot which have offices in Seattle, but we don't deal with education issues or health and human services. Do you remember when UW had that breach, of privacy breach, and somehow, it happened right before the pandemic, I think. We got a huge volume of calls for people contacting us about the breach, the healthcare breach of privacy. But that is primarily the reason, is that we just don't have jurisdiction over those entities. We get calls from all parts of different parts of Washington State about different things, but we don't have jurisdiction. Another thing is we don't have jurisdiction over federal employees, state employees, county employees. We don't have jurisdiction if someone feels like they're being discriminated on a metro bus or on Sound Transit. That is under county and state jurisdiction. So, even though that we do have a, city of Seattle is very large, but it's pretty concentrated just in things that happen in Seattle or connections to Seattle.
I understand.
Yeah.
Seattle Office of Civil Rights versus the EEOC. What makes them different?
Yeah, so it really has to do with the laws we enforce. So EEOC is only going to enforce federal law. So that means there will be a number of protected classes that will not be covered under federal law, including gender identity, sexual orientation, which they just kind of put out there. EEOC did. There's other types of protected classes. Also, we have a 1.5-year statute of limitation, which is different than under the federal law, which is 100 days. Federal law requires a certain threshold of employees versus under our local laws, it's 1 or more employees. So there's a lot of jurisdictional differences, and then also, like I mentioned, the backlog. The EEOC office here in Seattle has about 6 to 9 month backlog of federal cases, of discrimination cases, because they handle, Pacific Northwest, they handle Alaska, Washington, Oregon, Idaho, Montana. So it's a pretty large geographic area.
And your process will walk in.
Yes, so people can contact us by walk-in. We have an online, an online complaint form, by phone, by fax, whatever is easiest for people to file a complaint with us.
For those that don't know, can you tell us where you're located?
Yes, we are located, our physical address is 810 3rd Avenue, Suite 750, so it's in the central building. Our front office is open from, I think it's from 9 until 3, Monday through Thursday. We have a remote day on Fridays, and closed on holidays. Any other questions that folks have?
Thank you so much, Mike.
Thank you for your
Thank
time.
you.
Thank you.
Thanks for your tech support. I didn't,
No, we appreciate you coming, and I think we will, when our meeting work slows down for PSCSC, we'd love to have you back to the commission as well.
Okay, thank you.
The next order of business, we'll move to the executive director's budget and the department updates.
Thank you very much, Commissioner Caesar. We do have our materials here. We continue to work on our departmental work, developing our budgets. And I'd actually like to hand the mic over to Sarah Butler to give you some highlights from our recently published 2024 annual report.
Thank you. So I believe you've all received a copy of the 2024 annual report. Just a little bit about it. This is the first report that has been done in the department for a very long time. It's been 20 years. And I did a lot of kind of research, trying to see, what kind of formats we might want to use, and other jurisdictions, other organizations within the city. But finally settled on, what kind of report is going to best align with our values and our goals as a department. And that was to be something that was really accessible, something that would tell our story, and something that would educate people about what we do. So this was written for a very broad audience. It does not delve too deeply into kind of technical details of the civil service system. And it's this 13-page document. There's kind of an introduction to what civil service is, kind of as a concept and how it fits in with the city of Seattle. It is issued by the department and then contains sort of background and work of each commission in here. I guess there's like a work chart, scholar staffing, 5 highlights of our accomplishments in 2024, which we went over late last year, but they're included in here as well. And then pages 8 and 9 are really specific to this commission. So we have our roster of commissioners, what our core functions are. And then there's a table that shows a summary of employment actions that we review and just monitor as a commission, and those are probationary dismissals and then higher levels of discipline, such as suspensions, demotions, and terminations. And here they are from all the departments. It was an interesting exercise. I'm still kind of feeling our way through how to best transmit this information back and forth, but for the departments that report to us, this is the information that we have. There were no appeals that were filed in 2024. Reflected there. And then the remainder of the report is related to the Public Safety Service Commission. One chart here that I'm very excited about is a summary of all the exams that commission did, which is pretty astounding. They processed over 8,000 applications. They administered, upward of 5,000 written tests and practical examinations in all reports, and delivered to each department close to 2,000 eligible candidates and registers. So that's a huge body of work that our exams unit does. And then, some reporting on employment actions for that commission, and then a list of the appeals satisfied. Sure.
Can I just add for the list of disciplinary and other employment actions for both commissions, those are reported to us. Departments are required to report those to us by rule. However, we can only report what we actually receive. So it's possible, and Sarah did a lot of outreach to departments here to try to make sure that we got accurate numbers, but it's possible that those are not entirely accurate. We hope that departments, by having these published, will take notice and ensure that we are notified of disciplinary and probationary separations for employees in these two systems. Thank you, Sarah. This is a lot of work. This is a culmination of a lot of work on your part, and I'm really happy to see our first annual report published in a very long time. Now that we have some resources and some people to be able to put towards this work, it's just very good to see it all come together.
Yeah, I think it looks fantastic. Thanks, Sarah.
Thank you.
Did Commissioner Whiteman, Wing Whiteman say something?
She just said it was a
White Williams said yes, I just said that I was saying thank you to Sarah though.
Okay. And thank you, Sarah. Yes, a very comprehensive and really enjoyed this report.
Thank you. And help our reviewers and our team. Lots of folks that contributed to this.
Thank you. Okay. We still still on the executive report, budget updates? Updates?
Yes, sorry, my brain's right here, okay. You'll find, towards the end of your packet is the budget report. You know, this is expenses by month, labor and non-labor. Please follow up with me if you'd like more detailed information. But we're not yet seeing the carry forward here either. That I understand is pending with whichever committee, city council committee have taken a look at that. But we are well within our spending for the year. We will see a lot of invoices for consultant costs, especially for our exams unit come through towards the end of the year. So while we're at 35%, we're more than 35% of the way through the year. You know, I expect us to be right on budget for the end of the year. It maybe a little bit of underspend, but not a significant amount. And I'm happy to move on to the case status update. If that's all right with you, Commissioner Caesar?
Yes.
All right. So we have our case status report. That is the last page in your packet. We have one active appeal before the Civil Service Commission. That is Brown v. Seattle Parks and Recreation. We did conduct a pre-hearing conference in that case in late April. And we are working on the parties are in the discovery phase right now. We are going to be reaching out to commissioners in the next couple of weeks, maybe the next week, to talk about availability to schedule a hearing in that case. Teresa, remind me of how many days we think that case will need. Was it 4? 4 days. So more to come on that. Ms. Jacobs will reach out to you. Also with a list of witnesses to ensure, or for you to tell us whether or not you anticipate having a conflict of interest in that case. All right, that concludes my report.
Thank you, Dr. Shirley. Our next item of business, are there any new business? If I may bring something up, I read in the bylaws that my term is to serve a year
As the chair.
as the chair, and I think we're probably embarking within that period of time. About now, I'm not sure exactly what the date.
Did you take over for Commissioner McMillan halfway through the year?
Yes, about halfway through the year, as your highlights indicated, about half a year in. So we're about half a year.
I'll take a look at that rule. I'll take a look at that rule and we'll touch base with you, Commissioner Caesar. I wonder if it, you know, I wouldn't mind you completing this year in your term as chair. But you know, we'll get some legal advice and talk to you about how to proceed.
Okay.
I thought that we did another vote at the beginning of the year.
That's true. That's what we typically do.
That's right.
I think Commissioner Caesar, took over for Commissioner McMillan halfway through the year. So we'll just check on whether or not he can continue the rest of the year as chair.
Even though we took a vote to vote him in separately as chair in January.
Yeah, right.
Mixing up all my racket sports now.
Yeah. We'll check in with Joe Levan and thank you for raising that though, Commissioner Caesar.
Okay. Okay. So we'll look at that at the next meeting.
Sure.
Okay. All right. I guess there's no other business at this time. So do we have a motion for an adjournment?
I make a motion to adjourn.
Motion has been made to adjourn the meeting. Is there a second?
I second.
Second, motion is to adjourn. All those say aye. All those in favor say aye.
Aye.
All those opposed? Hearing none, this meeting is adjourned. It is now 3:02 p.m.
Great, thank you.
Thank you.
Thank you. Bye-bye.
Bye.